Good morning, and thanks for tuning in to SBAM's series of webinars with the American Arbitration Association. We're pleased to partner with them to bring you some content on arbitration and mediation. I'm going to turn it over to Catherine Glody to introduce our special guest today.
Hello, good morning, everyone. Nice to see some of you again. If you've seen some of our other webinars, you'll be familiar with me as I've done a couple of these featuring our Michigan-based panelists, and we have a very special Michigan-based panelist with us here today for our third and final of the webinar series. Let me just tell you a little bit about her. Here she is, Tracy Allen. She's an international professional mediator, arbitrator, and ADR trainer. She's a litigator, business tax attorney with many years of experience, and she now specializes in conflict resolution. She also teaches at a variety of law schools. Now, this is the Cliff Notes. She has a long, beautiful bio, and I'm sure she can link us to a website if you wanted the full background, but it would take up the 30 minutes. That's how esteemed our panelist is today and how much experience she brings to the table. So, Tracy, I just want to introduce you briefly and thank you very much for joining us here today with our SBAM members who will be tuning in live and many of whom will be watching the program after the fact. So, I'm just going to go ahead and get started here and say, Tracy, tell us a little bit more about your background and what makes you passionate about ADR for small businesses.
Well, thank you to AAA and SBM and everybody for giving me this opportunity. I love meeting people and helping educate people in what I call the family business of dispute resolution. I have represented hundreds of small to medium-sized businesses, have done a lot of merger and acquisition work, transactional work, litigation, and now I'm full-time arbitration mediation. But part of the reason I'm passionate about it is I'm an efficiency expert and I sell risk. And I don't like to see people get consumed with the cost and the expense, both hard and soft, in disputes. So that's what makes me passionate because I think most people want to live in a peaceful existence. We get along with people most of the time. And when the wheels fall off the bus, I want to be a fixer.
I think that's wonderful. And I just want to highlight, Tracy, our panelists come in with this breadth of knowledge and background. So Tracy, because she was a litigator, because she was on that ground, because she's uniquely familiar with exactly what she said, we've got to look at the bigger picture here. We have to look at the cost, right? The actual cost, but also these other costs associated. So it's really, unique. Our panelists come in with these specialty backgrounds, but also this real life experience that they can bring to the cases that they serve as a neutral on. So thank you so much for sharing that. I mentioned earlier that there's two other webinars, and I just want, because we're going to dive right in. We're going to dive right in with Tracy. We're going to talk about mediations. We're going to talk about arbitrations. But we also, I just want to refer everybody, we have two other webinars that are in the archives right now that folks can watch that are going to dive into them more than we can today. The first one is called Is an Arbitration Clause a Good Fit for Your Business? And the second one is What is ADR and how can it help your business resolve disputes quickly and effectively? So those two webinars, one focused on arbitration and one focused on mediation. And the goal today with Tracy is to just touch on a little bit of those, right? For folks that are not able to watch in the archives or don't have enough time, they maybe have a little bit of knowledge, but we'll reframe it just a touch today. But if you want the full background, please refer back to those webinars and watch them in full. So, so all three webinars will be available for viewing later. Okay, so but Tracy, we have you here now, and for those who aren't familiar, what is the difference between mediation and arbitration?
So one of the great things about AAA is they were really the head of the game in creating an arbitral opportunity for people and specifically for businesses. The arbitration notion is something that comes about by virtue of a contract between two disputants. So if you're building a building with the builder and the owner, they have a contract. If you're a supplier and a manufacturer, you have a contract or a purchase order, or you're buying a business or selling a business, or maybe you're in a limited liability company and the members want to have some mechanism for resolving conflict within the members. Lots of places you can put an arbitration clause. Many of them, and probably the vast majority of them, include the American Arbitration Association as the place to go. So if you have a contract to arbitrate, or if you get into a dispute and want to arbitrate, even though you don't have a contract, you can use AAA. The arbitrator is an independent neutral. Arbitrator comes from the panels that AAA creates. They have specialty expertise, they have experience. The arbitrator, think of the arbitrator as a judge that you picked. Unlike the courthouse where you file a lawsuit and you get a judge you don't even know, in arbitration, you can pick your decision maker. So the arbitrator is just like a judge. The only difference is you got to pick him or her, and you might pick one or you might have three. So if you have a really significant dispute and you want the view of three people, you can have panels of three. They have to be majority rule. I have yet to serve on an arbitration panel of three where we have not been unanimous in our rulings. The other issue about arbitration, the only negative, is that it's very rare that you can appeal. Now, some people say that's a negative, but AAA also has appellate rules for unusual circumstances. The great thing about arbitration is you're in and you're out. There's not a 2 to 5 year window post the hearing and the decision making to go through the Court of Appeals or the higher courts of your state or federal. So we like that. So you pick your decision maker, they have power like a judge, you can get through it faster. AAA's rules have a whole efficiency, economy, philosophy that the arbitrators subscribe to. The downside is you have to pay your decision makers, but it's a known payment. You know what you're in. And so we tend to streamline it to reduce legal costs and the arbitrator costs. We speed it up so that you can get through it quickly. We like to get them done in a year. And it's a much faster, more efficient process. That's arbitration. Mediation, you also select a third-party neutral. Again, you don't need a contract. Many mediations happen without even lawyers. Good business owners can come to mediation and negotiate their own disputes. The mediator doesn't have any power, but the mediation process is confidential, which means what happens in mediation stays in mediation, and the mediator facilitates communication and negotiation between the disputants to seek a livable solution to the dispute. And those solutions could be something more than what you could get in a courthouse. So that's why the judges like mediation, arbitrators like mediation. You keep control of your outcome if you're in a mediation.
And Tracy, one thing that I really like about mediations, I'm a former mediator myself, is sort of creative solutions, things that even a judge wouldn't be able to order. That could be something like an apology, right? That could be something, it could be whatever the parties craft. I'll give you an example. In a case, you can actually change the reason for, again, voluntarily, both sides agreeing to do this. You could change the reason in someone's personnel file while they were terminated. You can have a sit down and really explain what happened. And then if the parties agree that this is one way to resolve that dispute, the parties can agree and make that change. Right? But it's always interesting to me what the parties didn't get out. And when you bring everyone to a table and then we find out, okay, that's what the real issue is. That's why this person is really, coming in guns blazing because they're upset about this. And so we can kind of tack some of those head on. But so, the interesting thing is, what about Tracy? What about a mandated mediation before arbitration? What are your thoughts on proceeding in that manner?
We are seeing more and more of that now, and I like early mediation. I mean, you didn't get into the dispute in a day. You might not get out of it in a day in a mediation, but if you bring the mediator in earlier, you have an opportunity to have these confidential negotiations. You have an opportunity to streamline the areas that you can agree on, reduce your going forward costs of being in the conflict. You get this opportunity to do these extrajudicial things. I think what's important for our business owners to remember is that often their business lawyers are the ones drafting their supply contract or their employment contract or their buy-sell agreement. And it's a throw-in provision at the end to think about, well, what if we get into some conflict? And the good news is the proactive lawyers and the proactive transactional people with the blessings of their litigation departments are putting these preconditions in because there's a high probability the case is going to resolve before it gets blown up. Mediation settles about 60 to 70% of the cases at the moment. So if you have a mediation first and you can figure out whether you can find that livable solution or identify what more information you need to further your negotiations, why wouldn't you do it? It's 99% of all lawsuits in this country never get to judge or jury for decision making. So you're getting ready for a 1% probability. Why wouldn't you want to take advantage of the opportunity to have the 99% happen sooner?
I love how you phrase that. And I think this ties to a psychological principle. I don't know if we've ever been in too deep with something. You could be in too deep with a remodeling project. You're like, listen, I've already put 100 hours in, like this is going to happen. Like I am in too far deep to pull the plug now. This happens in litigation too. The parties get in too deep and they have spent too much time and money. So kind of what Tracy was saying, that early resolution, bringing everyone to the table early on, because unfortunately, once people get in too deep, sometimes they get those heels stuck and it's more difficult to move. And so that's why it's nice to have, and we'll go over clauses on our last 10 minutes here, but I'll show you how to put that mechanism in to say, you know what, before we arbitrate, we're gonna agree before a dispute happens, we're gonna agree that we're gonna mediate this first before we arbitrate for this very reason, because we know going in that once people dig their heels in, it is going to be much harder to seek resolution. And also folks get tunnel vision too, and they stop seeing the negatives of their cases. Tracy, have you ever had examples with that kind of that tunnel vision, or what are your thoughts on
Oh,
folks
yeah.
digging heels in?
Everybody falls in love with their case. Lawyers fall in love with their case, maybe even more than their clients. This idea of early resolution has been built into the American and Canadian Ambassador Bridge, the Gordie Howe Bridge that we're building. It was built into the reconstruction of the Capitol in Austin, Texas, and it was called real-time mediation. And if a dispute arose on the job site, they brought in the expert HVAC mediator or the expert contractor, and they negotiated. And if they could get it done, great. And if not, they just parked it, and it kept the projects on time. They didn't, everybody got the progress payments when they should. So, keeping an open mind when you're in the conflict, when you have these contract clauses that force that, help eliminate and reduce some of that. I'm so in love with this, I can't see the, forest for the trees.
And Tracy, I've never heard anyone call it that, but I'm going to steal that idea from you. So talking about falling in love with your cases, because that you put it so well. That's
Yeah.
exactly what happens. Um, we have a lot of small businesses on the line, and I'm making an assumption that small businesses are focused on growth, right? So when we're talking about unique advantages for ADR for small businesses, can you think of some that these small businesses would a real unique benefit? Like I could think of one right now that we were just talking about, preserving relationships. When you're a small business owner in a small town and there is one vendor that can supply this particular thing to you, and you all have gotten into a dispute, mediation is a really good way to preserve that relationship for the future, right? Fortunately or unfortunately, we are operating in similar circles in the small business world, especially when tied to a particular community. So mediation can salvage those relationships. You're not going in guns blazing, in a courthouse, I'll sue you for every dollar you're worth. Like, we have a dispute, the widgets didn't get manufactured exactly as we would have liked. How can we see the path forward together? But when you have small businesses kind of focused on growth, Tracy, can you think of any other, advantages to ADR, either mediation or arbitration?
Well, I think you're right. You can preserve those relationships. It's private. Both processes are private. So you don't have the, newspaper sitting on your front doorstep. The neutrals aren't talking. The parties agree not to talk. They have a confidentiality agreement that they enter into in mediation or in arbitration. By the rules, it's considered a private process. So the decision in an arbitration isn't going to be in the public domain, unlike a judgment in a lawsuit. The other opportunity is if you're in a financial crunch and you can't pay your supplier, you have an opportunity to negotiate new payment terms, which is only going to help you stay stable and expand your business. If you're thinking about expanding your employment workforce, and you have someone who says, you terminated me wrongfully because I'm too old, or I'm the wrong color, I'm the wrong gender, you have an opportunity to work with that former employee, as you said, to maybe change the reason for termination, give them a different type of neutral letter of reference, help them, give them job placement, out placement services as part of a resolution. It's all part of preserving your own status quo so that you can not be distracted by litigation and disputes, but focus on building your business and expanding your business. And once the community knows that you're an open-minded vendor or an open-minded business person, that only helps your reputation. And we all live and die by our reputations, particularly in small communities. So I think it's a real valuable resource to not only stabilize what you have, but prevent you from distraction so you can build, so you can expand, so you can make a better widget.
Yes, thank you, Tracy. I loved what you said. I'm just going to phrase it a little bit differently. Privacy. I'm going to use that word confidentiality because one of the most frustrating things I saw as a litigant is people know that when you file public documents, like some people use it as a weapon, right?
Yes,
So we know that there are people who scour public courthouse filings. We think of it of like the Jen Ben divorce situation at the LA County courthouse, right? Where they're scouring for gossip in the certain news publications and things like that. So they can do that because those filings are open to the public. And parties, we know, I'm using that as an example, they put really salacious things in there, right? Because they
yes.
think that they're trying to get an advantage in the litigation. They're trying to paint a particular picture. This is, our business owners, this is not a family law situation. We don't do a lot of family law cases at AAA. However, the same applies for businesses. Do you want a former employee suing your business, talking, writing all kinds of salacious things that are filed in the public document? Because true or not, those are filed in the public document. They can make their way to a newspaper, and so on and so forth. Our entire filing system is private. It is not open to the public. And so it is just a very different dynamic from the get-go. And I think that the demands that I see tend to reflect that. You just see a lot, they're just not as salacious because there's really no reason to be, you know?
Right. You're absolutely right. I just had a situation. Here's a classic example of somebody moving from Bank A. They were moving their business from Bank A to Bank B. And in the process of changing a loan agreement and getting a new loan agreement with Bank B, Bank B ran a check on the public record and there was a lawsuit against the company that was pending in the public domain. And it impacted their ability to get the financing in moving to the bank they wanted to do business with.
Mhm.
And so, there's a classic example of how the public persona can impact your ability to run your day-to-day operations.
Yes, absolutely. And so, there are many advantages. And we've talked about them, preserving relationships, confidentiality. There are many benefits to sort of going this path other than the traditional court system.
It also keeps you off social media.
Yeah, Tracy, have you seen social media and kind of publicly filed lawsuits, or where are you seeing social media play in the
Well, you'll
most right
see a
now?
disgruntled employee put up on their Facebook page that, I'm going to mediation next week with my former employer and they screwed me over, blah, 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 blah. Well, when you enter into a mediation agreement or an arbitration agreement, that's technically a violation of the privacy rules that everybody wants and everybody's contracted for. So it tends to dummy down some of the LinkedIn, Instagram, Facebook, prattle that we're seeing now. And all of that's discoverable in lawsuits. So it amazes me when people put stuff out on social media that's not very helpful. You look bad, it's going to be used against you, and it hurts the person you're asking to write you a check.
I love the way you put things, Tracy. So what I like to do is if anyone has a question, please feel free to put it in the chat. But I'd like to kind of move our attention over to the clause builder tool because Tracy has told us all of these, unique features about ADR that may make it worthwhile for businesses to include in their disputes. But so the natural question is how? Okay, I believe Tracy, yes, I want to meet, I want to have my vendors have a requirement to mediate with me. How do I do this? Where do I start? I'm glad you asked. That's why we're here. But before we do that, Tracy, I want to make sure that we save just a little minute before we get distracted with the clause builder. If folks want to get a hold of you, do you have a website to refer them to? If they have a
Do.
private matter or an ADR matter or
I
question?
do. I do. So my website is hosted by mediate.com. So if you go to www.mediate.com/Allen, Allen, you'll find my website. If you Google me, my name will come up as a mediator, as an attorney, as an arbitrator, probably all over the world. I don't know how fast it comes up because I've never Googled myself, but that's my website. And my
Mhm.
contact information is on the website.
And and while we put that on there, a lot of these publicly filed lawsuits are hitting these Google searches. So, you may think, well, someone's going to have to like dig in through some docket. Not necessarily the case. You may see a publicly filed case on a Google search. So, okay, let's switch it over to how do we implement these practices? I'm a small business owner. And you are, inherently entering into contracts. What language do you put in your contracts to trigger this arbitration and mediation that we've been talking about? So I am going to share my screen and we're going to go over these tools together. So here we go. And so here is the website. It's just called clausebuilder.org. It's very straightforward. We also have an AI version, but I know people are still new to AI and it can be intimidating. And so we're just going to use the classic website for today. But if you have questions about the Clause Builder AI, I'm happy to answer them. It's going to be similar content wise. So here we have, it's just go to this site, and this is just describing what this tool, and that's the best word for it, is going to do. So, you accept the disclaimer here, this is not legal advice. Everything Tracy and I have told you today is not legal advice. Everything in the webinar is not legal advice. So, please keep that in mind as we proceed accordingly. So here, I just put in my email address, and we go on to the next screen here.
You know, Catherine, these
Yes.
clauses could be put at the bottom of a purchase order
Yep.
or, a vendor, an RFP.
Yep.
And they can be and you can see they're not very long and extensive, but they can at least form the contract for the requirement of arbitration or mediation. You don't necessarily have to have a 7-page document that says I'm going to mediate or I'm going to arbitrate. You have
That's
three
right.
clauses
That's right.
available here that these
It could
people
be
can
as
do
few
that.
as 1 or 2 sentences, as we'll see.
Exactly.
So here you're going to select the nature of the contract or the dispute type. And so, we have a variety of things. For most people, our most popular is commercial, right? That's like your widget, your contract for widgets. But also we have employment, we have construction, and so on and so forth. And then here's what Tracy and I talked about earlier, this arbitration, mediation, and then, if necessary, arbitration or mediation proceeding the same time as arbitration. And we kind of talked about some of the benefits of going with option 2 there. And then step 3, does artificial intelligence, arise out of or relate to the contract? So in this case, we'll just put in no. So here's our clause. It is just that simple. It is right here, drafted for you, copy paste, put that into your contracts. And that says that if the other party and you enter into this contract, you are both consensual or consenting to proceeding in this manner, which is if we have a dispute, we do mediation first through AAA, and then we arbitrate through AAA if necessary, right? But I do not want to miss out on these categories here. So this is what we call a standard clause, right? This is what we see most of the time. But nobody knows their disputes better than you, better than the small business owners. And so, for example, here is my favorite one is discovery, actually. So look at this here. You can limit the number of depositions. You can actually say, you know what? We are going to do this on what we call documents only, right? So when you're entering into, and we're just using this as an example, widget, it's like a commonly used example in law school. When you're entering into that, you're like, listen, this is a contract for $10,000 for widgets. I do not want to be dragged into a long, lengthy proceeding that's going to require, extensive document production and depositions and this and that, because I know that if there's a dispute, it's going to happen in this really straightforward manner. And I don't want to have to be bogged down by all of that. You would literally click this option right here. You would enter in the dollar amount, just as simple as this. If the dispute is less than, you pick the dollar amount. There shall be no discovery other than the exchange of documents. Okay, you can limit it in any way that you see possible, because this is important to do while everyone is still friendly, right? You decide on the front end. If this deal is going to go south, I know where it's going to go south. And I know that these people are going to try to drown me. If you've ever seen that episode of Suits I mentioned in the last webinar, where there's just boxes, floor to ceiling of discovery. And when you think of intensive discovery, that's what you think of. And so on the front end, you can actually make that change using our clause builder AI. And you can incorporate it into the various clauses. So, I mean, here it's requiring me to put in the dollar amounts. But see, that's one example right there. What about locale? So we're going to just click this for no right now. Locale. Do you want to be dragged? Let's say you're doing business with somebody from outside of the state, and they want to say, if there's a dispute, we're going to force you to go into Nebraska for a week or two of your time to litigate this dispute.
Awful.
On the front end, you can say, hey, I'm not going to do that. We do not have time to do that as a business. My lawyer is not in one of these locales that you desire. On the front end, I'm telling you that if something goes south, this arbitration is going to take place right here in Detroit, Michigan. That's where this is going to happen. And you literally add that on into your clause, and it's just going to keep building on top of the other things that you've mentioned. So this can be as simple or as complicated as you want it to be. Just as Tracy said, number of arbitrators. This is a huge dispute, and this is a huge contract. And I want 3 sets of eyes on this one. That would be this column up here. So you can literally customize your future dispute before it even happens. You can say, this is what I value, this is what's important to me, and you shape it. This is something that the traditional courthouse cannot offer you. This is a party-driven process. And this is at the forefront of everything that we do at AAA. The parties can decide on the front end, we want 3 arbitrators instead of 1. The parties can decide on the front end that their place of arbitration will be this particular state and city, right? And this becomes important. I mean, we do international cases. The language of the arbitrator, is the whole arbitration going to be done in French? That's important to know. That could really set somebody back if they are trying to litigate in a foreign language overseas, right? So these are just beautiful things. It's one of my favorite things to feature, but how easy. You just copy and paste into your existing contract. It doesn't have to be a special contract. The rest of it can be as the parties decide. This is an add-on, is a great way for folks to kind of look at it. So with that said, I told you the time would fly, Tracy, and it has. We are down to the last minute or two. Did you want to give any kind of final thoughts or comments to our listeners at this time?
One of the things on this clause builder, if you don't feel you have the ability or competency to get these things into your contracts and you work with legal counsel, refer them to this clause builder tool. It's fantastic. And as an arbitrator and a mediator, I love the language. AAA has spent a lot of time building this language. So be proactive with your counsel or your legal department and send them to this clause builder place to pick and choose all the things that Catherine was talking about, and it'll force them to think about it before the conflict
Absolutely.
arises.
Thank you for mentioning that. Thank you so much. Thank you, Tracy, for your time today. Thank you, Sarah, for hosting this webinar for us. Thank you to all of our listeners. If you have any questions, you can email me at glodyk@adr.org. Thank you all so much.
All right, thanks, everybody. Have a great day.
Yes, thank you both so much, Tracy and Catherine. That was invaluable information that I know a lot of our members are going to find useful. So we appreciate your time today. Thanks, everybody. If you have any questions, you can reach out to Catherine, as she said, or let us know, and we'll put you in touch with them. Have a great day.